another school of thought. And I think what it does is it's something that we will have to work out as judges through training, so that we have a sort of standard basic approach to these judicial settlement conferences, so as to avoid the impression of oppressing parties and forcing agreements, to avoid the perception of unfairness, to avoid the perception that I was not heard because you're coming to a judge, and then crafting short-sighted and not enduring solutions. So that little half-an-hour little session I had, agreement, was it a short-sighted? Well, it was not. I can tell you it was not short-sighted and it was enduring, but you have to be careful of how you craft your solutions. All right, so why are we doing this? Because it's a practical necessity. We just simply cannot try all the cases. You heard Justice Devines this morning. And also, I think, because it's a humanistic approach to delivering justice. It's a way where we as judges can deliver social justice. And this is a very long quotation from Lord Devlin about judges and the role of judges and what they do. And it was really an expression of, in the course of their work, judges often disassociate themselves from the law. They would like to decide otherwise. They hint, but the law doesn't permit. They emphasize that it is as binding upon them as it is not as upon litigants. But if the stroke is inflicted by the law, it leaves no sense of individual justice. Basically, I don't have time to go through everything, but basically he was just expressing the frustration of a judge in an adversarial system, being unable to deliver real solutions for real problems. So I think that the GSEs really fills the gap between law and equity. And for me, the claim on the face of the document is not the solution to the problem. There's a much deeper human element and desire, that is dignity, respect, the need to be understood, the need to be appreciated, and the value of relationships. And that really comes out in a GSE rather than any other method that we've tried. These conferences, there's an opportunity to transform lives. And it's an opportunity for us to creatively solve disputes and deliver social justice and foster a more understanding and peaceful society. In terms of the quality of justice, by having the GSEs in our armory, we have more time to devote to complex trials. We have more time for judgment writing, as Justice Devines told us this morning. And we give disputants creative, just, and practical results. And in the reality, what we've done is, in our interaction as a mediation board with people in terms of mediation and so on, the people would really love to resolve their disputes themselves. And the idea of settling disputes really resonates already with groups and professionals. And there's a demand for access to service to settle disputes amicably. And that's the reality out there. People really do not want to come to court. And in fact, if you do an apex of dispute resolution, you would see that really the court is really, at the top of it. I mean, because people really would think twice before they come to court. And even then, you still have a flood of cases coming to us. So you can imagine the kind of disputes being resolved out there without our intervention. The stats, you heard from Justice Devines on the stats, a 31% settlement rate and 100% satisfaction. We encourage parties to be more realistic about their respective positions. We improve communication between attorneys. We allow the party to identify strengths and weaknesses of their case. And we move the parties towards settlement and preserve the relationship between the parties. I think that was very critical in what we've been doing. We got some feedback from those who had participated in our pilot project. And the judge's approach was tremendous. I'm confident his input and suggestions helped to resolve a matter that was near impossible. And overall, the GSE opened previously closed doors of communication. The feedback was very positive from both lawyers and clients. Someone said that the judge acted tremendously. Prior to the GSE, there was 0 chances of settlement. And in a mere 2 sessions, settlement was achieved. The judge took a clinical and practical approach, highlighting the strengths and weaknesses. And Mr. Gurley, just coming back to your question about how long it takes, So frequently, if it goes beyond the 2 to 3 hours, we have another session. The problem that we've had with the GSEs, however, is in scheduling the second session. The second session comes, perhaps weeks after the first session. And in my mind, I think we need to get the attorneys, on board with the whole idea. If we start a GSE, let's try and see within 2 or 3 weeks we can get this thing resolved, rather than from month to month to month, and it becomes another case for trial.
Judge, I have a follow-up question. If at the end of your session, the parties have not reached agreement, and you suppose then to give an evaluation as to the strength or weakness of the case, what if the judge feels that he's not in a position to evaluate, or do you always express an opinion if the parties do not agree?
Well, there are two answers to that. If you're asked to give an evaluation,
and you feel that you're not really in a position to give an informed evaluation.
Well, that's a good question. I mean, if a judge feels that way, he would say that. I have not done it like that. I would say, based on the material that I have on me, this is a very preliminary opinion, because there are a number of things to happen. These are some of the shortcomings in your case. These are some of the shortcomings in your case. If the shortcomings in one case alone, I'll give that opinion, with the caveat that it is very preliminary and it is without, seeing all the evidence. A classic case was a medical negligence case. The claimant's case looked hopeless, because all I had before me was the pleadings, and he had to demonstrate a breach of duty based on medical evidence. And there was no medical reports as yet. There was no expert reports. When I asked, do you have an expert who's coming to give evidence? No, we haven't found one yet. We'll go on the internet and look for one. And I said, well, how much money is that going to cost? I don't know. Is this client paying you? Yes, but it's not much. So where are you going to go with this? And even if you bring that evidence, what evidence are you going to bring? Well, I'm not too sure as yet, and so on and so on. So you can, based on where we are, well, I can't see you going far. All right? But that case could mushroom 3 years from then into a great case for the claimant once the evidence comes in. So I think we need to be, very careful in giving the opinion, even if you have most of the materials before you. It still has to be couched where we are, based on what I see. This is where I see us going.
Having expressed the opinion,
and these are the challenges that you face.
having expressed an opinion at the end of the conference, and is there further discussion and further consideration as to what weight is going to be placed on the judge's decision, evaluation?
I'm sorry? I was thinking about something else. Yeah.
Having gone through the JSC and the judge having given his opinion,
Right.
what happens then? The parties have an opportunity to have further discussions as to whether or not they're going to accept the judge's.
Yeah. Well, there are two ways to do it. You express the opinion, and you say, okay, you guys can think about what I just said. I leave them, and then I say, okay, do you want to have another session to give this some more thought, or do you want to send this back to the trial judge? And in some cases, they say, okay, no, judge, I think, we'll take our chances. In other cases, they say, well, judge, I just want one more session so that I can confer with my client. We need to talk to some relatives. We need to try and get, The opinion really shakes them, because they're seeing you as somebody making an evaluation, and they're projecting now, well, it's more than likely another judge may say the same thing. So now they're really getting their reality check. And again, it comes with the caveat that, we still can't predict the future. No.
One of the things about statistics of 31% is that there is no measurement of the matter that failed at GSC and went forward for adjudication before the presiding judge.
Yep, that's true.
And on the doors of the court.
That's true. That's true.
There was no
So
measurement
excellent point, because
there were occasions, I'm sure there were occasions where people didn't turn up for GSC
Well, there are two.
They
Yeah.
hang tough
Yeah.
in the GSC, and then reality sinks in, and they start to get the fee on brief
Yeah.
requisition from
Two
the lawyer,
cases.
and then they say,
Two cases.
it's not okay.
Two cases come to mind. There was a case before me, people fighting over a shipment of pumpkins that was shipped and it didn't come in. It wasn't refrigerated properly, and so the claimant was suing the persons in charge of the storage for monies and so on. So they're fighting over pumpkin and so on. Anyway, so they went to a JSC, but it was not settled in the JSC. And I got the report from the judge saying, well, he gave an opinion, parties, didn't settle. But when they came before me about a month after that settlement was closed, I had a consent order. So the opinion had juggled given them that reality check in that session, yeah? No. A decision?
Well, what I mean,
And
settlement by way of the GSC.
right.
Is there an agreement there, or is it sent to the trial judge with the settlement
Yeah.
and a consent order?
Yeah.
Entered?
Right.
How does it
So the agreement is drawn up between the parties
at the GSC?
at the JSC, and the agreement would state sometimes, or the parties would agree, that this agreement will be referred to your trial judge to be entered as a consent order. Now that opens up. No, and I was now going to explain. This opens up a whole new world for lawyers in how to craft my consent orders, how to craft my agreements, because I think we need to go back into our civil practice and procedure and start using more tumbling orders, where you have in your schedule a number of things worked out. Like, okay, you have a libel and defamation claim, right? The claim is for damages. But what you've worked out is really, they were fighting over a fridge that was damaged, and the man decided to restore a fridge and buy an extra, something totally unrelated to libel. So you might think about, and then they might decide, look, we want these terms to be private and confidential. So think about how to use tumbling orders. And so be very careful of how you're going to enter this as a consent order. As it stands now, most, if not all of the, I'll say most of the agreements that come to us are entered as an order of the court. There were some that came to us with a note saying the claimant will withdraw the claim, no further intervention required. So all that was required by a claimant was just to file a notice. And clearly, they may have worked out their private terms. All right? I have seen one case where one party used a tumbling order, and I think that is a creative way of trying to reduce in writing whatever the parties have agreed to, creatively, but giving it the force of law. But if it's breached, you now have to go for specific performance of the terms of that agreement. Well, it depends on what issue has been settled. I mean, if it was one claim out of 5 claims, we will enter an order with respect to one claim. In fact, I did one for Justice Devines like that. He sent a matter to me, and there were about 3 claims. And after one session, we sent back the agreement for one. And I told them, I said, hold on, we can get the other 2. And then I think the next session, we sent back the other 2 for him. So, all right, so let me just... so division really is the trial court will now be seen as the last resort to arrive at a solution to a dispute. Mediation and GSC is to become institutionalized and realize the vision of the multi-door courthouse. And in achieving this, we will develop a modern, creative judiciary, truly delivering justice for all. We will put this on the Mediation Board's website and send it out to you so you get a better idea of what we're saying today. And the basic skills of the GSC judge will be almost the same as the mediator. empathetic listening, reframing, open communication, guiding and not overpowering the process, recognizing power imbalance, nonverbal language, maintaining poise, setting right tenor, building trust, guiding listening, reframing, empowering parties, aha moments, right? You just say something and aha. Yeah.
Lord, I thank you and Justice Lee have been doing such a fantastic job of promoting mediation, Jesse. I see once the country is sensitized, there will be an overwhelming response to these services. I know that so far only senior counsel are being exposed to training for judicial settlement officers. Are you in a position to use your influence to extend it?
Well, I don't know about using influence to extent. What I can say is that certainly we need to have a larger roster of settlement conferencing. And so we're going to, so that's a whole discussion that we need to have about rolling out training. What we're looking at, firstly, retired judges. We recognize